particulars do not square out with the offense as prescribed in law. And as such, Your Honor, this court must guard under Article 10 such kind of habits and conduct by the DPP and the police, and uphold the rule of law. It's only through your pronouncement, Your Honor, in such kind of a rare invitation that you'll be able to communicate to all and sundry that this is a court of law. It's not a court that is meant to square out political scores. It's only through that pen of yours, Your Honor, as you write.
Sorry. So before that happens, the court remains to settle political scores. I think you need to watch your words.
Your Honor, I rephrase.
Because no both sides respect each other.
Yes, Your Honor, I rephrase. With apologies. That this court is a court of law, and any person wishing to settle scores should do out there and not before this court. Most importantly, as I pen off, Your Honor, is freedom that is at trial, is at trial. And they say, Your Honor, deny a man anything, but guarantee him of his freedom. The freedom of expression and the freedom of speech. We still take the same route, Your Honor, that there is nothing to plead to, there is nothing to respond to, and out of nothing comes nothing. That the suspect who is before Your Honor be released on his own personal bond or reasonable bond terms. If the court will not be of the opinion of discharging him effectively, I oblige.
Your Honor,
Yes, I was trained that senior speak fast.
yes, Your Honor, they yield at the time.
Okay.
They have yield at the time. Okay. Yes, I always respect parliamentary practice. Steve Bogwa, here is my name. And Your Honor, I first want to treat myself as submissions by my senior colleague. And further mention that we have witnessed serious misuse of police power in this country, and very serious attempts to misuse the criminal justice system in settling scores, both political or social. And what we're witnessing today, Your Honor, is an incident of clear misuse of power to limit fundamental freedom of expression. If such charges will be brought in this court of law, it clearly means that none of us is safe out there when we give our opinion or statements that do not please those who are in authority. And since
Your Honor, I beg to object to that kind of line of submission by my colleague. I wasn't hoping to object. I think from what I got from my senior colleagues, senior counsel, is that they were objecting to the charge. It's not about the processes, it's not about the personalities that or whatever. But let's stick to the law. As officers of the court, let's not just draw conclusion without statements, without facts, unless he wants to take to the witness block. He gives us that narrative.
I humbly respect my colleague, but I wish to state clearly that this court, Your Honor, should not be misused by the state to limit fundamental right of expression, and the charge sheet before you is totally defective. It's our submission that our client be discharged.
Who will respond on the prosecution side?
Your Honor, respond briefly. Your Honor, the charge sheet that's before you has met the conditions placed under the Criminal Procedure Code. Which requires that the charge sheet contain the statement of the offense and the particulars of the offense. I look at section 94(1) of the Penal Code. Gives the offense for which the accused person is facing. It gives the elements of that particular offense. The purpose of mentioning these particular elements is in relation to the particulars. That's the quotation that my colleagues, my senior colleagues, have pointed out. The section brings out certain keywords, like for example, a public place, public gathering, threatening or insulting words or behavior. And the section goes on and on. Your Honor, the question as to whether that quotation meets the provisions of section 94(1) are evidential questions. Your Honor, I refer this honorable court to three authorities when it comes to such an offense. That is Jacob Nthigangari versus Republic, Criminal Appeal number 48 of 2014.
You have a copy of the...
I'll provide a copy. I didn't expect my colleague to raise. Jacob Nthigangari versus the Republic, Criminal Appeal number 48 of 2014. By Honorable Lady Justice Mushemi, who looked at the ingredients and the elements of this particular offense. You're on also the case of Mule versus Republic, Criminal Appeal number Mule versus Republic, High Court Criminal Appeal number 873 of 1982. Rona further, the last authority that I would refer court to.
Sorry, Mule versus Republic.
Versus Republic, 2006, EKLR, by Honorable Lady Justice Lesit, as she then was. Your Honor, these particular authorities go to the elements of the offense and what it contains, and this Honorable Court cannot go to the quotation that has been provided in the particulars. But the nature of the offense has been brought out in sufficient details to enable the applicant, to enable the accused person response to the accusation before him. Your Honor, the other issues raised by my colleagues I wouldn't want to go into them on the issue of whether this was an opinion given by the accused person, because these are evidential questions. As much as we are all entitled to our opinion, but our opinion should not affect the rights of others. We therefore pray that this honorable court finds the charge sheet properly drawn as drafted, and the complainant is listed therein. We so pray, and the accused person therefore take plea.
A very brief response, Your Honor. If you allow me to do the unusual, so that the court may understand the dilemma the defense is in, to read the charge sheet, so that the court, we can all hear.
Your Honor, just so that I may not appear to be disrespectful, I thought a rejoinder is only restricted to the legal questions.
Yeah,
if my senior colleague was interested in reading the particulars, she ought to have read them at the time was raising the objection, not at the time of the rejoinder.
I don't think so, Your Honor, because if he says that the charge sheet proves the particulars, I would just want us to go home with the ring of these particulars. That he is charged with offensive conduct contrary to section 94(1) of the Penal Code. The particulars: on the 29th day of September 2024, at around 16 hours in Kiambu County, within the Republic of Kenya, in a public place, namely Ruiru Stadium, used abusive words to it. I said, even if we were cheated, I swear to God again, I swear to God, truly speaking, truly to God, dogs are many than we think. We worked and worked and worked for someone. I swear to God, hustlers were cheated, Mama Mboga was cheated, were cheated, Boda Boda were cheated, clergy, bishops, pastors were all cheated, all teachers were cheated. Our only person who was remaining in the government, talking bravely without folding the tail, Gachagua. I swear to God, if they will take him home, ha ha ha. I swear to God that that person to burn in the stomach while dosing. Ha ha ha. Dogs are many. This is one. I swear to God, how comes we worked for him and does not appreciate us? It's the truth, but we said one thing: if they will debate that motion in Parliament, if they will take him home, the other side of Gachagua, the following morning, led by Kalonzo's team, they will debate the motion to take Ruto home. Are we together? There will be no time Gachagua will go home alone. They were elected on one ticket and they will go home together. If Gachagua goes home, Ruto will also go home. Together, we should maintain the chorus. All MPs on the side of sending Gachagua home early in the morning will also take them home. All of them will go home. The other day, they voted yes to raise high cost of living with intent to provoke a breach. That's the end of the quote, and then now it is added with intent to provoke a breach of peace. To what set of those particulars are we here for? I just want that the court's mind be applied to this, to see it discloses no reasonable cause of action, It's a lamentation on various issues around the country. This does not satisfy Section 94, subsection 1 of the Penal Code. Let those words jumbled up, mixed up together, go in our minds. Is this an offense to which one can plead? Are they multiple offenses? Or is it just a lamentation that the court is being asked to take plea on? A lamentation is the opinion of the person lamenting. So we leave it to the court, and like in the earlier matter, Honorable Waititu is a notable person in this society, being a governor, being a member of parliament, being even a councillor in this city. And he's been a deputy minister, a deputy mayor. We urge for free bond, so that as the court considers, because it may take the court several readings of this to try and mix what is being said, I would urge that he gets free bond. He will return to court, and then the court can give us its ruling on this. I urge you also to, let me leave it there so that my colleague doesn't get it.
Finally, Your Honor, we may appear on the same Friday at the same time. In the event you want to deliver the ruling on preferred. But Your Honor, look at the offense alleged and the particulars. The offense is that of offensive conduct contrary to Section 94, subsection 1. But at the end of the particulars, they say, with intent to provoke a breach of peace. So, you know, those are two diverse, distinct provisions of the law jabbled up in one piece.
Your Honor, just in brief, the point that my colleague raised that we had not touched on by reading the particulars of the charge, I just want to refer court to the earlier case that I had mentioned of Rahab Wairimu on the issue of breach of peace, because my senior colleague has taken court through the entire particulars. I would refer court to that particular paragraph, and I believe this court will be able to look at that decision. In relation to the question of bail, we have not received indication whether the ruling is immediate or not before we can give our views on the same. We'd like to get directions from court so that we can respond on that question of bail.
Just proceed and respond.
In relation to the question of bail, while we are not directly objecting to bail, we admit that Honorable Waititu has all those positions that my senior colleague has mentioned. However, I wish to bring to court, unlike the previous case that this court has dealt with, Honorable Waititu has an ongoing case before the Anti-Corruption Court and is currently out on bail in that particular matter. Therefore, his terms must be stringent to reflect that he has an ongoing matter. Your Honor, just to mention, the word stringent is actually depends on how stringent the court looks at, and depends on how my colleagues look at the word stringent.
The offense before you, Your Honor, is a misdemeanor whose fine is 5,000 shillings. So when setting bail, that's how stringent. I just wish to draw the attention of the court to that. And even though he's on other cases, he has not failed to turn up in court. He dutifully attends all his cases.
So, Mr. Ndimu, you'll have to provide copies of the authority you are relying on, so that, even to your colleagues.
Yes.
And without reading them, I cannot give you a ruling, otherwise it will not be a considered one.
I undertake to provide them with
Yes. So what time do you want to come for ruling on Friday? Same time?
Time as the other one.
You want to come physically or virtually? Let's make it virtual because of the numbers.
No, let's come.
We would appreciate that.
And depending on the outcome.
Maybe whichever way that it goes, we should do it physical for purposes in case, just in case court rules in our favor, this person can take plea. In case in the event it doesn't, it will still no. Yeah.
May I wonder whether a plea cannot be taken virtually? Really?
It depends.
You can clearly see it with them.
It will depend on what happens thereafter. After the plea.
If they are admitted to bail now,
Yes.
it means that they're still bound by the court. A mention date can be set.
Okay.
If the plea must be physical, a mention date for the plea can be set during the virtual ruling.
You know, we also give directions on the phone through the schedule.
Mr. Ondimo wanted to.
In terms of those particular phones and wherever that was his bail police, yes, I'll cross-check with the investigating officer to see whether they have any evidential material. I undertake to ensure that my colleagues are informed before the end of business day. Yeah.
You are done? Okay. So ruling on the application relating to the charge sheet on 4th of October this year at 2 p.m. physically. With regard to the question of bail, the alleged offense falls within the category of those covered by Article 49, Sub-Article 2 of the Constitution, in respect of which an accused person should not be remanded in custody. There is no indication that the accused person has failed to turn up for trial in any other case, and the presumption of innocence under Article 50, Sub-Article 2A of the Constitution applies in all cases. Article 49, Sub-Article 1H of the Constitution provides for release on bail or bond on reasonable conditions, and therefore there is no provision, even under Section 123 of the Criminal Procedure Code, for stringent conditions sought by the prosecution. I am convinced that the nature of the charge is not one that can motivate the accused person to fail to turn up for plea taking. The accused person is therefore granted personal bond without surety of Kenya shillings 50,000 to appear before court on 4th of October this year at 2 p.m. Mr. Omboy, we have to break for lunch before coming for your matter. So we come back we can have 40 minutes break, we come back at 2.
custody. Moving on, self-declared public auditor Morara Kebaso is in police custody after he was picked up by the police in Kahawa Sukari area earlier today. Morara, who is being held at the Nairobi Region Police Station over unspecified charges, is expected in court tomorrow. This as former Kiambu Governor Ferdinand Waititu is spending the night at the Pangani Police Station over incitement allegations. Dennis Aseto has this report.
Activist Morara Kebaso is in police custody following his arrest this afternoon. Morara was arrested and taken to regional police headquarters for unspecified offences, with his lawyers being denied access. His lawyer, Pareno Solonka, says that Morara has been held incommunicado.
They've said, quote unquote, that they have strict instructions from the top, not to allow anybody access to Morara, including lawyers, media personnel, and other persons.
And it is this statement that sealed Ferdinand Waititu's fate after he found himself on the wrong side of the law.
Huko tumetoka na tumebeba mizigo yetu yote. Sisi mizigo yetu yote na mali yetu yote iko na mheshimiwa Dr.
Police say the arrest was necessary to prevent more inflammatory remarks.
Whoever is interrogating, whoever is holding Waititu, it is the office.
Waititu's legal team and other political leaders trooped to DCI to gather more information and determine the next steps, but were denied access.
That's why we are saying this is intimidation, because Wakenya wakisikia mtu amepelekwa kwa makao makuu ya DCI, ni kama kuwafanya wawe na hofu. We are going to demystify this itself. This DCI thing is not above the law.
I can tell you that Baba Yao spoke in Kikuyu. I understand a bit of Kikuyu. But like any language, I can tell you in my language, we have a saying in Luya that a dog does not eat, it's only the dog that eats its spittle. That is Kiluya. Ni msemati wa Kiluya ambayo you can use figuratively. It doesn't mean that means whoever has used that saying is calling you a dog. No.
Recently, Waititu has been actively campaigning alongside political leaders, including Kalonzo Musyoka, against perceived poor governance, with Morara making countrywide tours highlighting various ills and mismanagement of funds by the government. Waititu is locked up at Pangani Police Station ahead of his arraignment tomorrow. Dennis Aseto, KTN.
Thank you, Dennis Aseto. Meanwhile, Kenyans have urged President William Ruto and his deputy Rigathi Gachagua
Well, welcome back and thank you for staying with Newsline. We continue informing you about the latest developments. And right before the break, we took a look at what the law says and the process of removal of a deputy president. So now you're in the know in case that comes to the floor of the House. But remember, an impeachment is a political process. And that's why we have a politician in studio to take a look at the latest the latest matters arising from that particular talk around the impeachment of the deputy president. I'm joined by Peter Kihungi, who's the Kangema Member of Parliament. Karibu sana to our studios. It's a pleasure to have you with us.
Okay, thank you very much. Good evening.
Well, we are talking at a time when it's all to do with the political talk, and the political talk is centered right now on impeaching the deputy president. We don't know if it will be substantiated later on. But in case it is, it's proper to have this conversation. So looking at the tyranny of numbers in Parliament, it seems the numbers do not favor the Deputy President's camp. But the challenge would be substantiating the claims, the grounds of removal for the Deputy President. So from where you sit, are there grounds to impeach the Deputy President, or this is simply an effort in futility?
Okay, thank you very much. I think it is very clear that the grounds are the gross misconduct and gross violation of the Constitution.
Yes.
And everybody, and mostly members of Parliament who have proposed this issue of impeachment are the one who carries the ground. But this thing has not come from the public, from the general public, whereby you can hear there is an outcry and a complete outcry, impeach this guy. Therefore, they hold it as their agenda. It's an agenda of a few members of Parliament, if not a few. If they are majority, they are the one who are holding the issue of impeachment. And therefore, if they are the one who holds it, because if maybe he had been prosecuted in court of law, he has been taken through a process outside the Parliament, and now the members pick from that, then we could have managed to follow on the how gross misconduct, because it's not clear even in the Constitution. It just said the gross misconduct, violation of the Constitution, but doesn't come clearly with explanation, a very clear explanation. Therefore, if maybe the Deputy President did something that angered the general public, then maybe the general public took him to the court.
Okay.
Then, through that process, we could have managed to get the gross of the violations that he has done or the misconduct that he has done. But now, that thing has not come out clearly. Furthermore, let me tell you, most people are in panic. They don't believe it. They still believe this is just I was listening to other stations as people discuss it, because it's a discussion now to the public.
Yes.
And most of the public feel it's a decoy because of the politics maybe of Adani and whatever. But somehow silently I've listened to Parliament and I feel as if there's an impeachment. But the only people who know about the impeachment are the members who are proposing it. The public doesn't have an idea. Furthermore, they are so confused.
So let's talk about what those members seem to be proposing and what they seem to be accusing the Deputy President of. They say that he's undermined President Ruto's leadership and has caused divisions within the Kenya Kwanza administration. You're a member of Kenya Kwanza. So has the DP caused divisions within the Kenya Kwanza administration from where you sit?
Now, from where I sit, I don't see the division. Because as I stand here, the president is my president. If the president wants to come to Murang'a, he comes comfortably. There is no talk of people of Murang'a, where I come from, where maybe the division maybe has caused is between the people from maybe the area that he commands, mostly the Kikuyu area, the Kikuyu region, let's say about it.
Yes.
But recently the president walked around Murang'a, there was no violence, there was nothing. Because like the time of Kenyatta, if we could have taken the incidents whereby President Kenyatta was stoned, then you can take truly the deputy president or the vice president then has brought division that has made people maybe to be violent and something physically possible you can be able to explain. There is a division. But the president the other day went around central Kenya, Murang'a, all over, but there is no division. Any member of Parliament, there has not been any violence that a person went to the public and maybe was bashed, was stoned, there were riots. Kenya Kwanza is intact on the ground. It's only the normal division that has always been there between us leaders due to interest. And these interests mostly don't pay power jiko. They are interests that are personal. Therefore, the issue of division doesn't come anywhere.
So what do you think is the issue between the president and the deputy? Is it a personal issue? What exactly has caused the center not to hold any longer?
Let me tell you, I had said it somewhere. That where there is power, I don't want to put the word that this Nini use, but where there is power, there is a lot of competition for attention. And therefore, there are so many people who want the attention of the president. And that's what brings a lot of division between the center of power and the people around it. Therefore, there is no clear definition on the division between the president and the deputy. Okay. Because even the president has not come out clearly, even to the public, to say that the deputy has done this to me. It's only the competition between people who are trying to access power and prove they are more powerful in power. Let me tell you, they are reasoned. They are reasoned. But now comes in that for me, maybe to be able to operate in a within the power, I must remove maybe somebody.
Okay.
And that's how maybe some of the people who are very aggressive in the activity are trying to do.
So you think the DP is being targeted? Just
no,
for those
the
reasons,
DP, let me tell you in clear terms, is being targeted in the public. Let me tell you, you being a person from the public, the DP has not, there is no alteration between the president and the DP. Because what happens? There is also there is a version in the law that says, try to use all other means before you go to the issues like impeachment. Because let me tell you, there's nothing dangerous for the presidency to do, to open an impeachment for the presidency. Because the presidency is one. The president and the deputy are conjoined. We will start an impeachment for deputy president, but we will start an impeachment for the presidency. And it will be one of the worst things that can happen. Nobody can open an impeachment for the presidency because you don't know how it will go.
Okay, so it might be opening a can of worms and we don't know the political blowback thereafter. Let's talk about this censure motion that seems to be going to the floor of the Senate, because it's basically a motion intended to state that we are not happy with you, or a criticism or expression of disapproval of one's conduct. Of what consequence? You're a member of parliament, you're in a position to tell us, what exactly is this censure motion? What's the end game here politically?
I think the censure motion that was brought by Mugatana. But that one, I found them together with the deputy president today. Even I went through it, it was not well thought.
So they were...
Yeah, because also he was not very clear.
Okay.
Yeah, because he was not very clear. But maybe what happens is that whenever there is an issue that maybe some of us politicians, that thing can make me popular, other than the works I can do on the ground, the projects I can do, or the deliveries I can deliver to my people, I can pick something that I may think is very popular to the general public. But then immediately I pick it, I realize the general public has nothing to do with it. Let me tell you, the impeachment of deputy president, even in the areas of opposition, is not a popular issue. Because they feel the government should be targeting on service delivery. Because Kenyans are suffering.
Sure.
We have come out in a very tough space whereby they started with the COVID. Then immediately after COVID, there were demonstrations after elections. Then after demonstration after election, the agencies came. Then after agencies, we agreed, let's bring everybody now together so that we can be able to run this government peacefully. Then we introduce impeachment. You see, nobody, you don't understand. Furthermore, I'm trying to think, and now those people who vote about impeachment, what do they have for Kenyans? These people don't think about Kenyans, let me tell you. They think about themselves, their comfort, and the access to their power, and to feel they are powerful. And nobody is maybe challenging or in between the power that they want to enjoy. But Kenyans are not in this impeachment. They are nowhere. They are nowhere, let me tell you. And Kenyans are not happy. And I think that's what happened to Mugatana. Mugatana tried it and realized the people from his constituent, that is his county, has nothing to do with it. And therefore he withdrew it immediately. It was not even discussed. I saw them together today. Therefore, the issue of impeachment is not a priority for Kenyans for now at all. Those are small things that can be handled between ourselves, disagreements that can be handled between ourselves if we are humble and not proud. Because pride, that's what is driving us to excesses. To these excesses whereby I don't want to listen, we can't sit, we can't talk. And now we are putting our general public in a very tough space. Because this impeachment, let me tell you, it might bring other demonstrations. This impeachment might now turn maybe to the impeachment of the president himself. and the country will be ungovernable, let me tell you.
Interesting.
Yeah.
Well, it's proper to have this conversation. Peter Kihungi still joins us. He'll be coming back to studio at 10 p.m. at the top of the hour, where we'll continue evaluating some of these talks, the political talks around the impeachment of the deputy president, if they will be substantiated, to what political effect. And equally, it will be interesting to get his take on the matter around the NGCDF, because members of parliament seem to be defending it to the last man. So stay tuned for that.
We are traders. It's in our DNA to make bold decisions when everything is on the line. Born to thrive in chaos, to stand tall while others crumble, to battle in the world's greatest arena, the markets, and to know